Hello and welcome to another episode of the Melbourne Athletic Development Podcast. We are extremely lucky today to be joined by two wonderful people. They are both very high up in the legal world as either special counsels or Queen's counsels, and that is Helen Symon and Colin Mandy. Respectively, they work in two very different areas of legal practice. Helen working more in probably the more corporate side of things, Helen, and taxation, and Colin as a criminal in the criminal area of the legal practice. So what we've decided today is we're going to have a discussion about how they use their decision-making processes, how they come to their positions, and we want to get some insight into how they gather knowledge and interpret it so that it might actually help some healthcare practitioners to have a better understanding of what they do.
And start to actually pose some questions about how we need to think and challenge our own orders of thinking to actually ideally improve outcomes.
Yeah. So what we might do is quickly get you to introduce yourself and what you do. So I might get you to start, Helen, just a little bit about your background in the legal world.
Okay, I'm Helen Symon. I've been a QC practicing in tax and commercial for 22 years, and before that, obviously, I was a barrister as well. So it's me.
And Colin?
Yeah, I am a senior counsel for about the last 4 years practicing in criminal law, mainly in advocacy, jury trials, those sorts of things, both prosecuting and defending. My background's mainly defending, but I have done some prosecuting as well.
Cool. So if we put it to you, and as we go, we'll see how this works for our listeners, but I'm sure it'll probably be a bit more of an open discussion to normal, so you guys feel free to actually communicate between each other and ask questions, because I know that you don't really know each other that well professionally. So it'd be interesting to see the differences in what you do. But the first question that I'll kind of put to you is, do you have a process by which you go by when you receive, say, a new client or a new case to start formulating your position? Did you want to maybe give us some insight, Helen?
Okay, well, the first thing that happens is I get a lot of material to read. So there's a lot of reading to do to get the sense of what the facts are. In my practice, there's usually a piece of legislation, so I have to read the relevant sections. And
when you say read, like, how much reading are you doing? Is it days and days of reading, or is it?
Can be, yeah. Often it'll take me a couple of days to get through the material. I tend to read to get the shape of the thing.
Yeah.
So I don't read all the nuts and bolts and ins and out, because usually someone's given me a bit of a summary and some background. So I tend to find the things that give me the shape of it, and then go to the legislation to understand how that, what's been done is going to frame out under the legislation. So I get the legal framework, exactly.
And how long would this process take you? One thing that we spoke about just before coming on was, in healthcare, often you're expected to know the answer almost by the time the person's finished describing it to you. Whereas for you, I'm sure there's a lot more working parts, and it's a bit more complicated than just looking at, say, a series of symptoms or whatever presents. But how much time do you have when someone comes to you with a problem, and then you're sitting there going, okay, well, I have all this material, I've got to interpret it, and I've got to start coming up with, as you said, the shape of it. How long would something like that take on? And I know it probably varies, but how much time do you generally take with something like that?
Well, I've just done something recently where the client wanted advice in conference on positions that had been taken, or they were in the middle of an audit, so they wanted to know, what's my view of how that's going to go. And it took me about a week and a half.
Okay.
And I still wasn't sure about the answer.
Yeah.
So I find every case different. There's kind of like finding the way in can sometimes be a bit tricky. Sometimes what I do tends to be very conceptual.
Yes.
So the legislation could be very broadly drafted. Often it might be old legislation that the ATOs or the state revenue authorities are trying to apply to new situations, which makes it even more uncertain. So there's a lot of
grey area.
thinking about the facts and then thinking, no, maybe I need some more facts, I need to go a little bit more detail. And it just really, most often it just keeps swirling around until, one morning I wake up and go,
this is the position.
That's it.
Do you get all the data information you need from day one, or do you get a certain amount and then over time you go, actually, I need to get this information, I need to get that information, and you'll seek further?
It depends on the case. Sometimes if I'm briefed at the beginning of a dispute, then some part of it will be, I'll be advising on there's more material we need to think about this witness and that witness, or here are the issues which we need to pursue. Often it's further down the track.
You start exploring more.
Yeah, often not, someone's already thought about it and come to a position and they're asking me if I think what they want to do is sound. And often they ask me at the merits, are we going to win or not?
Yeah. Well, that brings the concept that Jack and I spoke about before this, but I'm sure for you guys, you're always thinking almost probabilistically. You're thinking, okay, if we take this argument, or as you said, a position or an interpretation, what's the probability that we're actually going to maybe win this argument?
No, we try not to do that. The clients always say, on a percentage basis, what are our chances of winning? It's like, oh.
Well, do you ever give a percentage basis?
I did the other day. But I always do it conservatively. I don't want to get them too excited.
Sure. With that in mind, is that something that you have learned? One, you say you sort of try to avoid it, but is it something that you do think in those terms about, okay, has this happened before? What's what's the precedence on this? Do I have a probability or understanding of what's going to happen and how this is going to be interpreted? Or is it not necessarily something that comes into your thinking?
Oh, yeah, always. But, I'm always asked, usually being asked whether they're going to win or lose, or what do they have a good chance of success. You usually get a feel for, well, it's a 50-50 case, or it's, better than 70%. But it's sort of it's always annoying to put a percentage on it because it builds up expectations. You always have a feel for, this is going to be a bit dicey. This one doesn't quite fit together. And you always know if you can be pretty sure about when you're going to lose as well.
I think that brings to me an interesting idea, and it'd be interesting to see what you say about this, Colin. But you're obviously a lot of the times either waiting on the decision of a jury, or you're waiting on the decision of a judge, or a mediator, whoever that person is making the decision. And I know that you mentioned before this, how it's sort of like it's the umpire's call and you have to accept it. In our profession, I think it's a little bit different at times because we kind of build up the evidence through like scientific inquiry, which is usually sort of like this gradual development of an understanding of an area, and then you kind of interpret in a certain manner. Whereas for you guys working in law, it's like someone makes a decision and then that then maybe sets a precedence for interpretation. How do you deal with that when a decision comes down and you're like, I don't actually really agree. I think we actually provided enough evidence to say it should be interpreted in this way.
Or you appeal.
You appeal.
I think there's a difference in that. In my job at least, and Helen's as well, we're arguing one side of a problem, and there's someone on the other side arguing the other side. So it's not like a health professional necessarily who's the person who's going to make the final decision.
Yeah.
In our case, we're arguing for one position and someone else is arguing for another, and it's that tension that needs to be managed. It's a process, and I think it's a process of experience. A lot of the time.
When you say experience, like what do you think has changed or evolved as you've gained more experience in how you deal with those situations?
I think getting to the heart of what matters about a particular problem more quickly than I used to.
Yeah.
So you get a brief that's 10,000 pages long or whatever it happens to be. And in the old days, you might have had to read most of that to get a sense of what was going on, whereas now the heart of the problem is quite clear and stark.
What is there some formality to how you develop that, or is there certain things that become sort of the key drivers for certain cases?
Look, I think because the people that I'm trying to persuade when I'm arguing a position is a judge or a jury, I know from experience that only arguing things that are sensible and make sense is the way that works. And I think when you're less experienced, you tend to argue anything that is possible without discarding the things that are irrelevant.
And is that sort of like an interplay between psychology and communication and understanding what people see as relevant, or is this more on a pure legal sense?
No, it's definitely listening as a human being to what other human beings are doing and saying and how they're describing it. That's a very important part of being an advocate. You know, you're communicating with a judge, you're having a dialogue with a judge, and you need to be able to listen to what they're saying and respond to it. And I think people who are better at being advocates are better at listening and seeing what's going on around them. Whereas with a jury, of course, you can't listen to a jury because you can't ask them what they're thinking, but the same sort of thing applies. That is, you need to be sensible and communicate with them on their level or on your level without being demeaning or those kinds of things. So my job is a lot about communicating. I think Helen's is too, with the client, with the judge, with the jury. I think your question was how you respond to precedent.
Well, I'll give you an example. I was telling Helen before. A close friend of mine, and I mentioned this to you before, works as a lawyer in New York. And when he was working here, a high court ruling in construction law came down, and he wasn't working in construction law, but he's interested in the mechanics of law and how it works and interpretation. And a high court ruling came down on an area of law that I don't think had been interpreted before. And Helen confirmed for me that when a high court ruling comes down, that generally becomes sort of the basis for how that law or act is interpreted going forward. And everyone started, all the legal firms come out and they start writing their articles or whatever it is to sort of promote that they understand what happens and promote themselves. And he was reading a few of them and he thought, I actually don't agree with this. And I don't know if I'm wrong or I'm just being a smart aleck or what, but I'm going to go talk with one of my professors at Melbourne Uni where he studied. And they got into a conversation and essentially he came back and he said, I actually think you've interpreted it right. And the High Court ruling was actually maybe not interpreted correctly. So they published a paper that sort of was in opposition to that ruling. And I don't know what's happening going forward with that law, but funnily enough, he ran into him at some function and the guy was kind of like, you smart ass,
Who, the High Court judge?
The High Court judge ran into him and was like, you smart ass, what are you commenting on what I'm doing as someone who's only got 4 or 5 years of experience? But to me, that's interesting because it's sort of like, as we mentioned before, the umpires made the decision and you have to just live by it. But clearly that can be wrong. It's an interpretation, and there's obviously lots of things that go into pick it, especially in complicated areas of law and the way that the language maybe is being written. How do you wrestle with that when internally you might actually be thinking, I don't actually agree with the position?
I'm not sure that it matters as much as you think it might, because there's 2 aspects to what we do. There's the legal framework, which is the legislation in effect, crimes, tax, and then there's the factual framework, and facts are never the same in 2 cases.
Yep.
So you can get the High Court making a judgment about what a particular piece of legislation means as it relates to a particular set of facts.
Yep.
And it's not, although it might be startling or new, it doesn't necessarily mean that every single case that involves that legislation has to be decided in that way.
Okay, so again, it comes down to the individual case that you're dealing with. Okay, that makes sense because it's similar in healthcare. Yes, this condition typically presents like this, but in this individual, we're seeing characteristics that are different.
Something interesting you said before, Colin, is you're constantly listening to the what the judge or the jury is feeling about the case. And I'm assuming you make adjustments to points you articulate or highlight accordingly. And it made me actually think straight away that's actually kind of similar to what we do, because you're seeing the evolution of the process over time. And that actually gives you real-time feedback and information going, I'm really heading in the right direction here. I feel like we're starting to get some traction.
Particularly even too from a patient. The way they respond and they're interacting with you will give you a lot of information.
Absolutely.
Yeah.
Because I think that's often the challenge. Well, I think that's one of the big challenges you said, John, before, of like the expectation of a patient coming in, particularly with a complex case, going, I actually need time to figure out what's going on here. And part of that is to, one, potentially collect more information, but two, see how the patient responds over time, because that's going to give you indications of going, okay, right, the input here or the process that we're taking is accurate. We just need to give it a certain amount of time to see the actual full resolution. And there's actually, at first I was thinking maybe that's not similar with in a legal setting, because it's just like a black and white outcome, which it is, but you actually start to, or you say it isn't a black and white outcome.
No, we have a few points where that kind of thing happens. So if you think of the beginning of a tax dispute, the commissioner will start an audit and probably take a position, but he'll be gathering a lot of information, and it might take a long while for the commissioner to really state what the position is. So in the meantime, the client's working out what the position, by reference to the information they're asking for, what the issue seems to be, and starting to formulate their position. Then you get the commissioner's position, which might need you to make a decision about the strength of your position, or adjust it, or you're going to understand it in a different way. Once litigation starts, there's a formal document where you state your position. It's called a statement of claim often, or an appeal statement, and the other side will put on theirs.
We might have to speak up against the rain.
Yeah. So again, you'll get more information and you're making adjustments. There's a stage where in commercial where written evidence goes in, and again, you'll make adjustments at that stage. And when you get into court, all bets are off, because once you get into court, not so much what I do, but Colin will tell you, you have witnesses in court, you have a judge, you have another person talking on the other side, you've got a jury. It's like whatever you thought was going to happen never happens. There is just, the end of every day, there's always half an hour where you sit down with the team and say, okay, so how are we going?
That's where there's very interesting.
It's a bit biblical, isn't it?
It is.
I have to say that when you're saying that, Helen, I actually relate to it so much in thinking about how contextual factors influence so much the situation. Like, again, I'm sick of like the things that we do in a controlled setting like here, particularly with athletes, where you're like, yep, you're ticking all the boxes. We think that you're actually got adequate strength, adequate flexibility. You can do all the things you need to do for your particular sport. But you actually put them into the environment where they need to compete, where there's so many other extraneous variables, i.e. opponents, playing conditions, peer pressure, crowd pressure. It starts to throw in all these other things where you actually your confidence of knowing what the outcome will be can start to be more compromised.
I think that's true, but I think there's another difference between what you do and what we do, which might be important, and that is that you've got a client. We've both got clients. Boys have got clients. You've got clients, but your client comes to you with a particular problem that you can treat one-on-one. And sure, you can't control what happens once you've treated that problem and they go out into the world. Whereas we're looking after our clients and trying to do the best for them, so that's the same. But we have to deal with parameters that we can't control, which is the case, the context, the judge, the jury, witnesses, all of those sorts of things. So it's like we're looking after our client, and that's the important relationship. We've got to do the best we can for our client, but we can't control things outside of that relationship. You can't control things outside of that relationship either, but it's one-on-one between you and that client.
Yeah, and I guess in your situation too, in that setting, there's nothing that the client can do up to that point. That they're at the mercy of everything else going on around them. Yeah.
Sorry for the interlude. We had to stop there for a moment. Just the weather was getting quite scary. But where do we want to pick up from, Jack?
Well, perhaps we should talk about some of the points you want to discuss, John, in regards to thinking about the ethics behind decision making. I think they'd be useful to explore.
Yeah. I think one of the areas that I think to me is quite interesting, and it's not necessarily something that I think health practitioners necessarily think about too much, but is the philosophical sort of ethical position that you take when you're actually gathering knowledge and what kind of approach you're using. And one of the areas that I think is interesting is the difference between, say, utilitarianism, which is that the outcome justifies the means of getting there, versus the deontological approach, which is that each action on itself should be, say, potentially judged on a moral standard. And if it's in a healthcare setting, it's interesting because I always think back to sport. If it's a grand final, people will almost do anything to play, even if it's not the best medical decision. People will have local injections, all those kind of things.
Or you take someone out on the ground in the first quarter.
Exactly.
Your team can win.
Exactly. But we're not necessarily thinking about, okay, is this for the greater good, or is this, this action in itself the right thing to do or the wrong thing to do? And it's not something that maybe is going to be forefront of mind, but I think it's something in the legal world does actually become very relevant to how you or at least underpins how you guys think about formulating position. And I don't know whether you think about this stuff or not, but I'd be interested to know whether you actually, either of you, have kind of come across these kind of thoughts as you've been developing your ideal position on something.
Well, we're never allowed to work on the basis that the end justifies the means.
Yeah.
So we've got a very strong ethical underpinning.
Is there something that I know that you talk about this a lot in even your basic studies? How much time you spent going through the underlying ethics and philosophy of what you're doing?
Well, it's always there and it's always repeated. So as part of our continuing professional development, we have to do an ethics, some sort of ethics component every year. And the bar has an ethics committee. So if people run into a situation where they feel that they might have a conflict of interest, or there's a conflict between their duty to the court and their duty to the client, then they can actually seek some assistance and a ruling about the best way to proceed in that situation. So the ethics of what we do is taken very seriously.
Because I think it's interesting, and I think both of you would come to these different positions. I think for you, Colin, it's probably more apparent because I know that you work in criminal defence. And for you, I feel like there would be ethical considerations that you have to make all the time. Obviously, everyone is entitled under law to a fair application of the law, even if we use a hypothetical example, they are guilty and they've actually committed the crime. Everyone deserves their day in court, as they say. As a legal professional, how do you wrestle with that? Is it something that you consider, or are there underpinnings for you, even philosophically or in your value system, that mean that you value them actually having the representation at the right level to justify, representing someone who potentially is guilty?
Potentially is the key word there. So I agree with Helen. I mean, our role in the courts and for clients is highly regulated ethically. Not so much regulated, but the ethics are really very important. And so all barristers, their first duty, their primary duty is to the court.
Yep.
Over and above their duty to their
And
client.
when you say that, what are the things that you're having to uphold in order to actually maintain that?
Honesty, basically, with the court. So if your client says to you, in my situation, if my client said to me, I'm guilty, I did this thing, but I want you to plead not guilty, I can do that. But I can't say anything that contradicts their guilt in court. So say, for instance, it's an assault and they say, yeah, I did hit him, but I want to plead not guilty. I can't say to a witness, he was never there. You're lying about him hitting you. I can't do that because I know that he did, and I would be being dishonest with the court.
Yep.
So in those circumstances, there's very little that a defence barrister can do if they know that their client's guilty. You almost have to not say anything, depending on the parameters. And that's,
at the end of the day, it shifts to, because the Crown has the burden of proving guilt. So at the end of the day, you're left attacking the weaknesses in their case.
Without pretending that you weren't there or that you've got an alibi. Or
I think that brings up something that we spoke about, prior to coming on, which is this idea of, as you said, taking their position or them having to prove the guilt. And it makes me think a lot about, again, for us, people in healthcare, if we think about the ideas around philosophy of science of disproving, your position. And I know that I asked you guys the questions before we started. How often are you taking a position where you're trying to almost, disprove or take the position of the opposition so that you really understand your own problem that you're facing?
Always. It's always part of... you're always testing the strength of your own position by working out what the other side's going to say.
What kind of things will you do?
See what the other side's going to say, so you think it through. Think through the implications
Are you like getting... Sorry to interrupt you. You basically almost like getting, say, some of the other staff to sit down and actually work out, okay, well, we think this is the argument we're taking, or are you yourself doing that and going through every argument? What's the actual process that you go by to almost...
Yeah, well, you see what the argument is and you sit down and think about it. I usually think about it because I always have a junior, think about it with the junior or get their impression. And one of my practices in a case with witnesses is I always get the junior to prepare a cross-examination for the other side and have the witness experience cross-examination and understand where their weaknesses are.
Yeah. Now, the reason that I ask is it's something that I think we don't think about a lot, Jack, as healthcare practitioners, but we go through this process, we start collecting information, and we start from this idea of we kind of think what we know what's going on, or even if we don't, we just start collecting more and more information. But one of the flaws in that is we collect information that is very biased in that, confirmational bias sense, because what we do is we go looking for what we think it is. And we only gather the information that will support almost that basis that we have. I think very few people are good at gathering information that's not sort of being led.
I was going to ask, with you in your situation, Helen or Colin, how much information do you get about the opposing legal team and what they're going to say before the actual court hearing? Is there any actual documents that they...
Well, in my case, you get a statement of what their case is that sets out what they say the facts are and what their arguments are. And then before we go to court, you always get a full set of written submissions, like a full written argument.
Because the thing I think of straight away, John, going back to your point, is how good are you individually being able to challenge your own belief systems?
And that's the key thing that I think that part of talking to Helen and Colin is to try and help people get to this ability to actually question their own thinking.
Yeah.
Because we're really bad. Once we have an idea, we go down a path and we end up in a position that we've set for ourselves. And I think what's interesting about legal practice is you're constantly being challenged. Obviously, you have an opposition at times, but you actually have to start thinking in that way. I think it's important for us to actually start going, well, I've made this assumption based on some information that I've gathered. What would actually disprove this? And how often am I going and seeking out information that would disprove that? Because I don't think we do that ever.
What you need, John, is you need two physiotherapists, one prosecuting and one defending.
Well, it's not a bad argument, Colin, because I think it's something that obviously happens, I think, when you've got access to, say, a medical team, if you're in a sporting environment, and they do have bigger teams where they sit around and they go, well, no, I think it's this, or no, we need to look at this further because I think that's what's been contributing to this hamstring strain injuries we've been having at this footy club, or whatever it is. But I think as an individual practitioner, you're not necessarily taught to think in that way where it's like, okay, well, what do I do? For you guys, and even for you, Colin, I'm sure now that you've got lots of experience, you're already almost thinking about what the opposition is going to say. Is that something that shifted in your experience as you went on, that you started to understand the kind of arguments that come against the positions that you take as well?
It always depends on the facts. So I don't think
it varies from case to case.
It's not very easy to make a definitive golden rule for all situations, because it's always going to depend on, especially in crime, on the facts.
Even then, so does that mean that at least, even if you don't have the specific arguments that you're setting out, do you have a process that you go with? As Helen mentioned, she'll sit with a junior and they'll go through that, and then they'll obviously get the information from the opposition. Is there a process that you have that allows you to start doing that?
In crime, you always you always know what the prosecution's case is. So if I'm prosecuting, I have to set it out. The defence don't have to set out what their case is. They have to say what's in issue, but they don't have to tell you which witnesses they're calling, those kinds of things. So I just had an example where I'm prosecuting a case at the moment where the defence went into evidence and they called a witness, and I had no notice or inkling of what this witness was going to say. And he gets into the witness box in front of the jury and gives his evidence. And so I had to respond to that immediately without any notice or preparation to cross-examine that witness about what that said. So if you're prosecuting, you need to tell the defence everything. If you're defending, you don't need to necessarily reveal your hand, because that's consistent with, the prosecution proving the case, the defence not having to prove anything.
Yeah.
But I think it's useful what you're pointing to, though. I mean, we do have processes where, part of the process that I'm talking about when I get the other side's submissions to sit down with the junior is often because I have to do a reply.
Yes.
Or I'm going to be opening the case when I get to court and make an oral opening. And so there are actually processes which require us to think about and integrate. But you do have to catch yourself sometimes. People get lost in the argument sometimes.
Yeah.
They go, this is what we say the legislation says, and so they go with that's the argument, and then people get all massively excited about the history of the legislation, which is usually completely irrelevant, and weird and wonderful arguments about context and purpose, which is helpful often, but often not the key thing. And the best lesson I ever had from a silk I used to work with was, he used to say, what does the section say? And there is nothing that beats going back to the basics and reading the legislation again, because sometimes you realise you've gone off on some little frolic and forgotten that the word isn't and, it's or.
Yeah.
and that makes all the difference.
It's really valuable. There's so many areas, and I always think this to research, for instance, because you see these veins of research and you often see research teams and they're just going down this path. And if you're someone who's skeptical, which, Jack and I tend to probably sound a little bit more skeptical.
Really?
You picked that up?
Yeah. But one of the things that we often do is we won't agree with maybe even their central hypothesis of what they're working, and they're digging this hole, I don't know to where, and it's like they think that they're going to come up, as you said, they're going into the history of the law and they're getting all excited about it, and they're getting so excited they think they're going to come to this golden finding, and eventually often it peters out or it goes nowhere, and it's almost like no one in that research group stopped and said, wait a minute, your basic premise that you're working from isn't that solid to start with. Go back and actually think about or question what you're doing.
But the other thing with that too, John, is I think of some examples of researchers who think they're onto something big, and they're stuck in their own little web.
It's a bubble, And
then if they actually look a bit more beyond their own research or talk to other researchers that related to their field, they realise that that's actually been explored already.
Yeah. Or
they already have come to significant conclusions about whether they think it's going to work.
We've seen that a lot, and I know probably people will find this controversial, but I think that happened a lot in the tendon research. I think it happened
muscle architecture.
Muscle architecture research.
The whole biomechanics versus tissue capacity.
And I think a heap of even really good research was done, in the muscle physiology, understanding of the neural drivers and things like that.
Yes.
That was done in the 70s and 80s.
Yeah, by
and people are coming back and having those discussions. It's like, you haven't actually learned to look outside your own little, as you said, bubble to realise you're going down the wrong path.
That was actually a question I was going to ask you too, but I think you answered pretty well, Helen. What's the difference with your ability to identify the most relevant information in a case versus, say, your junior or someone with less experience? But I think you probably highlighted before of actually just going back to the fundamentals of what determines the decision-making process for the judge or the court. Would that be fair?
Well, sometimes it is, but I think one of the things that happens with experience is you do, I mean, and Colin said at the outset, you do get a lot better at understanding the framework. So I work with a particular junior who is he's really great on the detail, but he disappears into the detail. And I'm always looking back to what's the framework? Let's see what the framework is, and then we'll go into the detail and see if the detail fits that framework. That's what I'm always looking for, because I've got a good feel. I've usually got a good feel for, look, this is what the law is. This is what the facts are going to do in this. So I think this is what the case is. And then then the junior's job is to say, yes, the evidence supports that, or to say, no, we can't. It's not going to work to put it that way.
Well, that was going to be my next question is, do you find you have many experiences where a colleague who has less experience, you actually learn something from them, or they actually challenge your perceptions? Because, I think one of the issues you always have with experience is that can also help reinforce your own bias, which can be problematic. And, the idea of experience can be
I always
useful.
assume my juniors are way smarter than me, so and they usually are.
That's a good way to look at it.
Yeah.
Well, no, the reason Jack brings that up, but I don't know if either of you are at all familiar with a researcher named Philip Tetlock, and he wrote a book called Super Forecasting, and it was about the ability for experts to make predictions or forecasts. And basically, I think one of the quotes from an article that he got interviewed by The Atlantic after he'd written a number of papers was that experts are no better than chimpanzees throwing darts at a dartboard when they are, making predictions or forecasts. And the reason is, as I said, is over time you develop really strong biases. And I think it's interesting, as you said, like in your profession, I think you get called upon very often to question those biases because, as you said before, Colin, there's external factors that actually influence the outcome, not just you and the client, which I think is actually interesting for people in healthcare, because we don't often get that unless something happens sometimes in, say, compensation claims, where it has to go to like an independent medical, assessment or something like that, where someone goes, wait a minute, you've been dicking around now for 12 months, like get on track. For you guys, I don't think that happens as often because you go to court and someone actually makes a decision. And to me, I think that is a really valuable lesson to learn, to have people consistently questioning, one, what they do, but also having other people question what they do.
I think one of the things which is really useful is to bear in mind what Colin said at the outset as well, though, that our job is we're advocates and our job is to persuade. So one of the things that I find in the tax area is, tax is really technical, and, all sorts of people want to show how incredibly intelligent they are because they understand all this tax technical stuff. And I've had arguments with other people who say, yeah, but you're a tax lawyer. And I go, no, I'm not a tax lawyer. I'm an advocate. And so you can be the great tax technical person, but I'm the advocate. And that's one of the things that stops me getting stuck, because I don't want to be the tax technical expert. I'm not particularly interested in proving that, but I do want to take the tax technical stuff and be able to use it persuasively.
Do you think, like, this is a conversation that we've had previously about the difference between sort of really specializing and maintaining some generalist qualities? Is that something that you found, helpful in that role you're saying as an advocate, is that you don't see yourself as being so technically driven and so deep on the details when it comes to the taxation, that you can actually zoom out a bit and go, oh, wait a minute, I understand this, so therefore I can ask these questions? Yeah,
I've always said that if you come from the focus of advocacy, you could actually do any area of law. All you need is, especially as silk, all you need is the junior who can have you understand the framework you're working in, and then put that into the process of persuasion. The trouble is people don't do that. I mean, you get typecast, so you get stuck in your area.
But you were asking about whether you ever challenge your own, and I don't think I've had a single case or maybe a single day in court that's been intense where I haven't walked out of court and gone, should have asked that question. Or I should have made that submission.
One of the I remember actually as an inexperienced clinician, I used to have a lot of days like that where you walk away and you go, I made the wrong decision. I diagnosed something wrong or I did the wrong thing, and the outcome isn't, it's not in our line, thankfully, of what we do. It's not fatal. It's not like we're dealing with medical interventions that are life or death, but you have that sort of sinking feeling, something like, I stuffed that up, or as you said, I didn't ask that question and I should have. As like
almost every single time.
Yeah.
Even now, do you find that you're having that still happening often? Because, as I said, the way that your profession is structured is like people basically their role is to actually ask those questions that maybe you haven't thought of, or and how do you, as a practitioner of law, but as a professional, how do you deal with that?
Well, you learn from it, I suppose. Is the most. I mean, it happens. The things that where I do that now maybe are more nuanced and minute in the scheme of things, whereas 20 years ago, maybe sometimes they were bigger than that. Why did I call that woman to give evidence? She absolutely destroyed my guts. I don't make that kind of mistake anymore, but I still walk out of court. I mean, I had an example the other day. I was doing a final address to a jury and I said something during the final address and I was thinking about it afterwards going, why did I say that? That was a stupid thing to say. And the other side picked it up and said, he said that. So, you learn from these things.
What's that growth mindset? I think the thing that stands out too, and you said, Colin, is like asking you general questions. You say, it really just depends on the individual circumstances and case. And I think that seems like an obvious thing in healthcare too, but more often than not, you'll see it within our profession of, you have these more generic questions of how do you treat like a hamstring strain? But you don't necessarily, I can't imagine someone asking you that question of like, how do you defend someone?
Defend them,
How do you treat a murder?
because there is so much of this nuance that needs to happen at an individual level. Is that kind of like an overriding principle in legal practice, particularly for you guys that are more senior, that you do have to individualize to every single situation, and there isn't a way of just giving generic advice? And I know that sounds like a dumb question, but I'd be interested to know what you
Depends how much time you've got to prepare the answer. Like if it's off the cuff, then it has to be more generic. If you've got a lot of time, it gets more specific.
Yeah. The reason we ask that, and Jack sort of alluded to this, is one of the things that we're battling against heavily is this idea of like protocols in healthcare. The simple reason that they might be useful, as you said, like generic advice might be useful, but if you got an individual in front of you, and to us, we really value that people's health is extremely important. Obviously, that's why we do what we do, but you should actually treat that individual with the respect to manage their individual case appropriately, rather than just going, oh, here's a piece of paper that will help you fix your injury. Like, I don't care about your individual situation, just take that and off you go. And it's good to hear that at your senior level, that's something that's almost a central premise. Like, you won't give advice unless you really understand what's going on with that specific, client.
Yeah.
Anything else you want to explore, John? Any of the other questions that?
I think the good thing is they've pretty much answered most of the areas that I think we wanted to touch on. Was there any other comments that?
I thought we were going to get into some Kant, Immanuel Kant.
Well, we asked a little bit about deontology. Do you want to go down?
No, not really. I could only sing the Monty Python song. That's all I know about Kant.
Well,
was that the exam for that particular part of ethics? Was it?
Immanuel Kant was a real pissant. It was very rarely stable.
Well, yeah, I think that side of it, I think, is, as I said, it's very much conceptual, but I think it's interesting just for the simple case that for you, obviously, that's what you do, is you're trying to help someone and advocate for them on the individual basis of each thing that happens. I think it's interesting in terms of the way society is run, but that's probably a broader.
But what do you guys think that you learn from this conversation about our practice?
It actually reinforces to me some strongly embedded beliefs I already have. For better and maybe sometimes worse, I'm always someone who's questioning a lot of the decisions I make.
I think it's around confirmation bias of us inviting them on. we want to convince other people
It's getting too meta for me.
Yeah.
No, but that's one thing I always think of, like, was that the best decision to make? It's also, part of that's challenging because, like John said before, we typically have depending on the patient's expectations, we have very limited time to collect enough data to make quite definitive decisions early on. And that can be very challenging, I find, because typically as you see that person over multiple sessions,
your understanding changes.
And it's how do you word that towards a patient as well, going, oh, look, I've actually decided that that's not really your biggest problem, or we actually don't need, your plan needs to change accordingly. Because you can also lose, the patient can lose confidence in you very quickly. But
actually, that's probably something that's worth asking, because I think it's something that for both of you, one of the things that would be interesting is how you manage the expectations of the client and how that changes over time, because we have that problem, as Jack just mentioned. Something might be going well and then something goes wrong, and obviously you've developed some sort of relationship with them, hopefully, that they understand what your job is. As you said, for us, we see it similarly. We almost see ourselves as health advocates, not necessarily as, we're not the savior, we're not going to fix you, right? Even though that's sometimes the expectation that people have. And I think it's probably similar for both of you, where people expect you, like, you have all the answers, you're going to win this case for us. Whereas you're like, no, that's not my role here. My role is to give you, the most relevant information and provide the best arguments. But the law is the law, and it will actually fall on the side of, said before, what the court decides. But
you don't make the decisions, or you don't make the decisions on the outcome ultimately, do
No,
you?
so the difference might be that your client's expectations are incremental. So you're making them feel better each session until an end point where they're better. Whereas our clients' expectations are the final, that surround the final decision of a judge or a jury or whatever.
Yeah.
So it's easier perhaps for us to manage our clients' expectations because we look ahead to that point and say, look, you've got a reasonable case, can't guarantee anything.
Is that something you have to be really careful of? I think probably as an inexperienced, lawyer, to not set expectations that are...
Well, I think that's interesting about what you're both saying, though, because it sounds to me like what's missing is the context for the relationship. That because people come to lawyers, you pretty quickly say, I can't guarantee you any outcome. It's not an exact science.
That's a really good point, Helen.
And
really good point.
I suspect that
that's
maybe...
the case for us as well.
Yeah, and I suspect that's
But
maybe
people have
not
that
what you do.
expectation.
You don't... Maybe there needs to be more explanation about what you do with your clients. I mean, frankly, if someone changes their mind along the way and I've got a relationship of trust with them, then I'm grateful for that. I don't want someone to hang on to some position to save face.
I'll give you an example. This has happened to me so many times, where you say to someone, they come in with a certain expectation, or they have, they've Googled it and this is what's wrong with me. They come in, you assess it, and you say, look, I actually think it's this. We're going to manage it in this way. And they're not happy because they've, in their mind, come to this position. And they go, oh, maybe we'll get looked in further, and, maybe you go and send them for some sort of imaging. And it confirms kind of what you were saying. Then they go, I'm still not happy. They want to go to the surgeon, right? Because for some reason, and in all professions generally, they're particularly historical professions, they're hierarchical. So generally, it's, the surgeon's the top of the hierarchy for musculoskeletal injuries, at least. They end up going to the surgeon says, the physio was right. Then they come back and they go, oh, no, you were right. And then they're a really strong advocate for what you were doing and they're your best friends. But the whole time before, they were questioning everything you were saying because they're like, you're an idiot. You don't know what to say. Like, you don't know what you're talking about.
Our clients are like that all the time.
Yeah.
That's true. But the other thing too is, I'm going to say, John, is for the clinicians who go, this is the problem, this is exactly what we're going to do, and you show that you're really confident about what the problem is and how it's going to be managed. And then obviously for the patient, like, yeah, this is great, I know exactly what's going to happen. But then over time you start to see the outcomes. They may achieve the outcomes you expect, but they may not, because they've become a bit too blindsided by thinking this is the problem, this is how we're going to deal with it, without actually seeing the change or evolution in how that problem or person deals with interventions and whether they're actually heading in the right direction or not. Because typically I find I become more confident over time as I interact with the person and see, okay, great, you're heading in the right direction. We're seeing improvements that we expect, as opposed to the other way around of like, I'm really confident, but then over time you're starting to go, oh, this isn't really working out how I thought it was, but you've set up this expectation or belief that you know exactly what's going on. But then there's that issue then too of, if you start really changing course, are you going to lose confidence in that person's belief in you?
Well, it's good that you said that. I think it's interesting because, as you mentioned, I think that as a health practitioner, you would struggle if the first thing you did was say, I can't guarantee you anything, right? But it seems like it's reasonably acceptable in legal practice to say, well, I can't, based on what you've told me, I can't promise you anything.
That's right. I think you're going to win, but what's the,
Or I can promise you that I'll do the very best for you.
Yeah, true.
Which is often what people want.
But there's also the other thing that, there's actually quite a lot of regulation around this as well, is that there's a lot of, not pressure, but whatever the word is, expectation us that we will manage people's understanding of the process. So, I spend a lot of time with witnesses before you go into court, for example, to say, when you walk in, the judge is going to be, if you can take them into a courtroom, great, the judge is going to be here and someone will open the court and you'll go into the witness box here, and people don't even know that, the other barrister's going to ask you questions and I can, but I can't help you when all that stuff. So we're actually managing people's understanding of the process and their expectations along the way constantly.
Is that something that you find improves the satisfaction they have and the relationship they have with you if you spend the time actually, as you said, managing those expectations?
It depends on the client. Sometimes they are. Sometimes.
Well, it's one of the.
Sometimes they walk out of court going, "Why didn't you tell me?"
Well, it's one of the things that we've been talking about a lot recently in our clinical practice, trying to improve what we do by saying, like, when you've got someone come in for an initial, actually explaining to them, these are all the areas that we think are contributing to your problem, and we're going to kind of, as you said, almost like walk you through what this process is going to look like, because we often have a problem here where people will come in and you say, okay, look, you've got 15 different deficits that are contributing to why you've got back pain. You fix one or two, they feel a little bit better, and then they don't want to come back again. And you say to them, like, it's not that you can't come back or that, that you're wrong by saying I'm not going to continue attending, but just understand that because all of these things contribute, the risk of you having another injury is likely to be higher than if you don't address those problems. And it's hard to explain that to people at times because, as you said, they just want to, all they want to get rid of is the pain. And once that's gone, they don't care that in 3 months they're going to have the same problem again. That to me has been a difficult challenge to work on, of how do we manage those expectations, and do we, how much information do we have to give about what the process looks like? It sounds like that's something that for both of you actually have to deal with pretty regularly, because otherwise you get them to turn around saying, well, you didn't tell me this.
Yeah. And now we seem to have the opposite problem in that people don't understand the process and they think, they come to a lawyer now, the lawyer's going to fix it. So when you're putting together evidence, for example, that they don't understand that they're going to need to come and sit in your office for 2 or 3 days while you
extract
get the evidence out of them.
It'd be interesting, actually.
And, they have to do a big process of finding all the papers that are relevant, all that stuff.
Maybe we need to set up the clinic accordingly.
Yeah, 2 to 3 day interview, an appointment to work out all of the information. Let's start at the start.
Yeah.
When did you start walking?
Do you think that would give you a better set of information as to how to diagnose?
Yeah, we've been talking about this concept a lot, where
there must be a point where the efficiency diminishes radically.
You would know, but because you were part of this, but we're coming up with some ideas around how do we start gathering more of that information and getting more insight into that, so that we can actually create better healthcare outcomes. Because I think it's one of the biggest problems that we face that holds back healthcare is it's very time limited. And it's usually because it's one individual dealing with it, and they don't necessarily have the funds unless you're in a special circumstance to actually put towards, okay, this is going to take me 2 to 3 days to sit down with you and really understand your medical problem. And I'm going to charge you, because you've got knee pain, I'm going to charge you X amount of thousands of dollars to do that. Most people are not willing to do that kind of, whereas for people who are seeking out legal counsel, they are willing to do it because potentially the ramifications are more significant for them.
And part of that, again, is context, because if someone comes in with, say, a simple ankle sprain, it's clearly more straightforward what needs to be done. But I think actually, John and I have talked about this. I think something that we are good at here at the clinic and that we're particularly interested in is complex cases. So people who have either failed conservative management because...
Or even surgical. You know,
or surgical, yeah, it's
you
true.
have people that, you know, they think that surgery is going to be their answer. They go and get the surgery and they're like, I'm no better.
But the thing that you find is to collect enough data, you actually need a certain amount of time. Like we've thought about, do we actually have appointments for complex cases where we do, say, a 2-hour consultation? Because you need to collect data from enough different areas to actually understand, okay, like we might need to address multiple factors here at once. Because the reality is if you're in a 45-minute consultation, there's a limitation to actually how much you can collect. But then part of that is, again, the expectation too, because if someone's got a complex situation where they've had it for a long period of time, they're probably more likely to be open to going, yep, I'm happy to do a 2-hour appointment, or we say to them, we're going to spend 3 sessions collecting data, then I'll go away and actually...
You know, speak with people, gather more information, do some reading.
And then actually put together some kind of plan of what are the factors that need to be addressed.
But does that affect the outcome, or does it just affect the time that it takes to get the outcome?
Oh, both, because like we need the time factor to actually collect enough data to determine what needs to be done. The actual process of getting a good outcome will just vary depending on what's going on.
Yeah, if it's something simple as like an ankle sprain, there's not a lot of complication in what you're trying to find and what's potentially contribute, especially if it's something like we talk about the difference between ordered problem and unordered problems, and those are the ones that have, you know, complex onset versus, you know, you fall over and you snap your arm. Yeah. It's pretty obvious why you snapped your arm.
Yeah.
But if you continue to get back pain, even though you've done all of these things to address it and it continues to happen, that might take a hell of a lot more. And there's a lot more inputs to what the mechanism was for the development of that pain. So,
and just the process of the timeline for adaptation. Because most often with complex cases, there might be, say, misdiagnosis where they're like, oh, you've actually got a stress fracture, that's why your foot's still sore, and they need specific management. But most of the time it's, oh, you actually have developed maladaptations over a long period of time, and we actually need to apply these interventions and develop these capacities, which may take weeks, months, depending on what the particular area of the body and individual factors as well.
So what other professions are you going to examine closely?
What do you think we should do, Colin?
Architects?
Interesting.
I feel like if we get too much into the looking at humans as an engineering problem, we could get a little bit...
Yeah.
Well, isn't it an engineering problem, just with a little bit more dynamism?
Well,
yeah, but that's...
It's incomplete.
Yeah. Well, as I said, it's more dynamic, so...
Then I would say that dynamic component is really important because there are clear mechanical factors, but the reality is how your body responds to mechanical factors is not just limited to...
It's not linear, yeah.
Yeah, it's not just limited to, like, we just need to build better tissue strength and therefore you won't injure yourself. Like, that's a big factor, absolutely.
It's not the only one.
Yeah.
And actually, that's one of the central things that is a problem for us at times is the underlying assumptions that people have is that humans are like machines. They think it's like they're like a car and they'll just get the parts changed or upgrade the parts and off they go. The problem will be fixed. And that's also, particularly in our area of musculoskeletal health, that's probably reinforced by, say, like joint replacements where people, you know, oh, my knee's bad, it's worn out, get a new one. Oh, I feel great, off I go, I can do things again. But the reality is the human body is not that simple, and ecological or biological systems don't follow those kind of laws. So that becomes a challenge of how do you unwind people's assumption that then things are mechanistic, which they're not always. And we all know this, if you give people certain examples, it's really obvious to them, but they don't necessarily always apply it. And the example I always give to people that's more in sports performance, but if you and I, Colin, do the exact same training plan, like we start doing a running training plan and we go for runs every single day, we do the same thing, and then we go to a 10K race, you probably run a hell of a lot faster than me, even though we've been doing the exact same training program. And the reason is, I'm complimenting you, may take it.
If it's 10K, then maybe, yeah.
But you've got a lot more aerobic training than I do in terms of your background. You swim every day still. Well, there you go. And that's the thing that people understand. That's like, okay, well, that makes sense that 1 + 1 doesn't always equal 2 in humans, but in injuries, they think it does. It's like, well, I got my strength up in my hamstring, so why do I keep tearing it? It's like, well, because it's not the only factor, and it's not mechanistic in that sense.
I think it's relevant for tell me if you disagree with law, because it's not just purely logical. There's so much subjective interpretation to what's going on. Like, actually, made me think, just talking about this, is like, do you think something like AI could essentially replicate or essentially do your job to actually?
Well, it's interesting, because in preparation for this, I started reading some stuff about this, and they said that like one of the problems that AI is having, they're actually using lawyers to help them work out how to make AI systems work. And one of the reasons is what lawyers learn to do is interpret things and be able to understand particular communication and language, which AI just can't, at the moment, just doesn't seem to know how to do, because it requires a lot of information coming from lots of different things to interpret even, say, one sentence.
But like, my point is then too, isn't that sentence open for interpretation itself of like,
well, and that's
how you interpret
problem.
It versus is different to me?
Yeah, and that's the problem.
And that's our job.
Yeah. and that's what the strength of legal practitioners is they get good at being able to do that.
It'd be nice to get an AI to read 10,000 pages.
And then just download it.
Well, there is a bit of that. They're using AI in discovery processes and finding that the AI is better at just finding what's relevant and pulling it out.
Keyword search.
Well, yeah,
It's funny you say that, because John and I are working on a project at the moment where we think of like technology is probably quite useful in healthcare for diagnosis, because you can start to figure out pretty quickly or give at least a probability of it. It might be able to highlight contributing factors to that diagnosis, but then whether it actually can address those factors, you probably need to have a much more nuanced approach to it. That a kind of generic algorithm may not be able to find a solution for.
Yeah. And the classic situation in the law is you can find all the relevant documents, and then in the tax area there's a lot of argument about claims to legal professional privilege. So there are documents that the other side never gets to see, and the law of legal professional privilege is so complex that you can put teams and teams of people on it. That you have juniors making decisions or law students making decisions, and then it always has to be vetted by someone up the line, because the decisions about what is and isn't privileged is so nuanced.
Alrighty, I think that we covered off on a number of topics there.
Yeah.
Hopefully the rain didn't ruin the audio too much, but thank you so much for your time, guys. We really appreciate you taking the time out to come and have a chat.